Okay, let's dive right into this. Welcome to today's Explainer, where we're going to completely unpack a topic that affects literally every single one of us. And honestly, it affects us on a daily basis without us even realizing it. We're talking about liability waivers, and more specifically, the deep, in-depth legal truth hiding right there in the fine print.
I mean, think about it for a second. You walk into a new gym, you're super excited to start your workout, and the person at the front desk casually hands you a clipboard. Or, you download a new app on your phone and you're immediately hit with an absolute wall of text and a tiny little checkbox. Do those waivers actually work? When you mindlessly click "I agree" or just quickly scribble your signature on that clipboard, are you actually signing away your legal rights if something goes terribly wrong?
We encounter these things everywhere. Gym memberships, app terms of service, hospital admission forms, adventure parks. You've probably signed a dozen of these this year alone, without actually reading them. And the truth is, most people have absolutely no idea what rights they're actually giving up. So today, we're going to go incredibly in-depth to figure out exactly what power these documents actually hold.
So here's our roadmap for this explainer. We'll define the legal fine print, move into the default rules of contract freedom, hit the legal boundaries, explore a landmark unconscionability test, check out modern consumer protection statutes, and finally, give you the golden rule of waivers.
Section 1. Defining the legal fine print. Let's get our vocabulary straight. Because before we get into the heavy law, we really need to fix our terminology here. Sloppy definitions are exactly where most bad legal advice goes wrong. First up, the waiver or release. This is essentially the classic shield. When you sign this before, say, rock climbing or surgery, you are formally surrendering your future right to sue for specified harms if things go sideways. It's a proactive mechanism to completely prevent a lawsuit before an activity even begins.
Next, we have the exclusion or exemption clause. Now, unlike a standalone waiver, this is a very specific, almost surgical term buried inside a massive contract, like a digital app's terms of service. Its job isn't necessarily to prevent a lawsuit entirely, but to cap or exclude damages for specific breaches. So if an app accidentally deletes all your data, this clause might limit their financial liability to, well, the $5 you originally paid for the software.
Finally, there's the indemnity clause. This one shifts liability in reverse. Instead of shedding liability, you're effectively assuming it. So if you drop a heavy weight at the gym and injure another member, an indemnity clause means you agree to pay the gym's legal costs if that injured person decides to sue the gym. Now, while they have different mechanical functions, Indian courts actually analyze all three of these under the exact same core legal doctrines, which means everything we discussed today applies to the whole shebang. Section 2. The default. Freedom to contract. This is our baseline rule.
All right. Let's bust a major myth right now. You might have seen videos online claiming that waivers are completely fake and totally unenforceable. That is dangerously false. The default rule under classical contract law is freedom of contract. This means waivers generally do work. As long as parties freely contract, an exclusion clause remains completely effective. You absolutely can contractually give up your right to sue. But the real substance here, the truly fascinating part of this topic, lies in the strict exceptions to that default rule.
Section 3. Hitting the legal boundaries. Basically, when waivers go way too far.
So, while you have the freedom to contract, the law has some very strict boundaries. Section 23 of the Indian Contract Act is basically the public policy check. It automatically voids any agreement covering deliberate harm, fraud, or acts wildly injurious to public safety. You simply cannot disclaim liability for intentionally hurting someone. It is void no matter how clearly you signed it. Meanwhile, Section 28 protects your fundamental access to the justice system. Its whole purpose is to prevent the creation of private, untouchable entities. A contract cannot completely block you from enforcing your legal rights in a legitimate court. So a waiver stating, you agree never to sue us for anything, ever under any circumstance, yeah, that's legally void on its face.
Section 4. The landmark unconscionability test. A truly pivotal moment from 1986.
Now, what's really interesting here is this 1986 Supreme Court case, Central Inland Water Transport Corporation versus Brojo Nath Ganguly. A massive government corporation essentially forced a standard form contract on a permanent employee, giving themselves the absolute power to fire him with just 3 months' notice and absolutely zero explanation. The employee challenged this clause, arguing that given the massive power dynamic, the clause itself was fundamentally unconscionable. And the Supreme Court actually agreed, laying out a 4-step reasoning that completely changed contract law in India. First, they noted it was a standard form take-it-or-leave-it contract. Second, it was entered into by an entity with massive superior bargaining power against an individual with virtually none. Third, the terms were deeply unfair and oppressive. Therefore, Step 4, the court ruled it void under Section 23 for being injurious to public interest. This is the foundational principle, explaining why a waiver you're essentially forced to sign, like say an emergency admission form at a hospital where you have zero negotiating power, can actually be struck down. Mere consent just isn't enough when the bargaining power is radically lopsided.
Section 5. Modern Consumer Protection Statutes. How the law handles this today.
So, different jurisdictions actually handle this legal puzzle a bit differently today. In India, Section 246 of the Consumer Protection Act of 2019 allows consumer forums to strike down unfair contracts that impose disproportionate penalties or totally unreasonable obligations. It's a highly contextual, case-by-case approach. Contrast that with the UK's Unfair Contract Terms Act of 1977. The UK took an absolute hardline legislative approach. A business is flatly prohibited from excluding liability for death or personal injury caused by negligence, period. No clever contractual wording or signed waiver can ever override that specific harm in the UK.
Section 6. The Golden Rule of Waivers. What you really need to remember from all of this.
So the crucial point is this. Here's the golden rule across all these in-depth legal frameworks. A liability waiver generally protects a business from ordinary negligence. A simple, honest mistake, like a gym employee briefly mopping a floor and just forgetting to put down a wet floor sign. However, courts will eagerly step in and shred that waiver if a business commits gross negligence, which means an extreme, reckless disregard for your safety, or willful misconduct and fraud. Furthermore, waivers born from severely unequal bargaining power, those take-it-or-leave-it standard form contracts where you practically have no true choice but to sign, those face massive legal scrutiny. So long story short, waivers aren't ironclad, but they certainly aren't fake either.
So I'll leave you with this. The very next time you are standing at a front desk, handed a clipboard with tiny fine print, or you're about to blindly click accept on a screen, pause and ask yourself, what exactly are you signing away? And, based on the unconscientiality test and the public policy rules we just explored in depth, do they actually have the legal power to enforce it against you? Keep questioning the fine print and never stop learning.